Okay, I was just watching public defenders arguing a case that state's attorney is creating trial publicity through the media because they know they can't win the case in court. So they're stoking fear through public opinion and through the media, through instilling fear in the public through the media. Okay, so I want to go to the rules of professional conduct on that. I had a lawyer one time argue with me on the internet. That was before I started my thing, legal reform, saying, because I used the ABA, rules of professional conduct, she said, no, that's the ABA rules. That's not my state. And so nobody was going to listen to me because that person was a lawyer and I wasn't. But this is what I said. The rules of professional conduct for lawyers are ethical standards governing legal practice based primarily on the ABA model rules of professional conduct and state-specific laws. They ensure integrity, competence, and public trust. So that there tells you the ABA model rule of professional conduct is what every state uses. Okay? And they can build on it. They cannot take away, which years ago some of them did, and that's what caused me to create legal reform and showing these people the laws on the internet. Thank God it wasn't the library. People don't do that. But the rules are the same in every state. Some have more verbiage than others. Some may have something your state doesn't have. And you can use that because it's in the public interest. Some courts don't like to acknowledge that, but you can use it. Okay, let's go to down here, trial publicity. I got to go through this arbitrator. They call it for eviction court, early remediation something, but it's just basically where they want you to talk to a lawyer. And he's going to try to want me to talk to a lawyer. Oh, people safekeeping property, nobody does that, guardianship, conservatorship. I seen some young lady, Britney Spears, get ripped off royally because nobody was safekeeping her property. Okay, so anybody communicate that to her, communicate any of this to her. It would have been diligent. It would have been competent. Those are rules, people. So, in essence, if your lawyer isn't going over this with you, I wouldn't recommend him or her. Declining or terminating representation, lawyers will get mad at you if you bring up this and they'll quit on you on the spot, which is illegal. Okay, duties to prospective clients, advisor. I was warning my landlord that his lawyer was his advisor. Did his lawyer advise him? Did all these repairs I'm complaining about are mandatory through law? Lawyer survey, meritorious claims and contentions, expediting litigation, candor towards the tribunal. Often lawyers will file a case without anything to substantiate that. And for some reason, they'll let it through, and then they'll argue. But no candor towards the tribunal because it lacked credibility. In criminal court, it's called probable cause here. You got to have something that just make this sustainable. Fairness to the opposing party and counsel. That's what the public defender was complaining about. The state's attorney's not giving them access to certain things in discovery. The state's attorney saying, well, it takes time. I got to know. That's failure to expedite litigation. That's a lack of diligence. That's not competent. That's what I call it, highly incompetent. Okay, trial publicity. That's the one I was looking for. A lawyer who is participating or has participating in investigation or litigation of a matter shall not make extrajudicial statements that the lawyer knows or reasonably should know will be dissipated by means of public communications and would pose a serious and imminent threat to the fairness of the adjudication proceedings in the matter. Notwithstanding paragraph A, a lawyer may state the claim, offense, and defense involved in, I'm sorry, it's just so tiny I can't see it. Okay, information contained in the public record, the investigation, and that. But anyways, you should go over this. It tells you the state's attorneys creating trial publicity, and the public defenders are getting death threats. Media follows around the state's attorney's office to see what they're charging people for, but they're not talking to the counsel for the defense because they don't know why. And that's what was going on in the courtroom, and the media was there, and the public defender was saying, well, I'm glad the media is here because now they get to see the essence of the case instead of listening to the derogatory statements made to sway public opinion. And it's forbidden. It's forbidden. Trial publicity. There's a lot to be said about trial publicity and how lawyers and judges involved in the case are limited on what they can say. They're not, it's illegal to create this type of trial publicity. We already went over special responsibility. See, it even says here. You could use that verbiage. The duty of a public prosecutor is to seek justice, not merely to convict. The prosecutor shall, in a case shall, refrain from prosecuting a charge the prosecutor knows is not supported by probable cause. Make reasonable efforts to assure the accused advised of the rights and the proceedings for obtaining counsel has been given reasonable opportunity to obtain counsel, which they don't do that. I got arrested, and when I asked for a lawyer, they always bring in the state's attorney, assistant state's attorney, and offering me plea deals right off the bat. Get the fuck out of here with that shit. Charge me and let's go to trial. Then they get mad because I demand a jury trial. Well, the judge ain't gonna like that. I says, you know what ain't gonna like what the judge don't like? The code of judicial conduct. Okay, not to seek or obtain from unrepresented accused a waiver of important pretrial rights such as the right to a preliminary hearing. And that happens when people get arrested. You ask for a lawyer, you got to watch who you talk to because they're not going to send in a public defender. Public defender's office ain't got no time for you, not even in court. When you go to court, they'll say, hey, sign this and you can leave, and then you're leaving with a felony. The last case I helped, this kid had 2 felonies, and he was about to get his 3rd, and I knew what they were going to tell him, and I found him, and I told him they're going to say, sign this and you can go, and he said, that's what they told me before. And I didn't fight it, and it took a long time the first time, and so I wound up having to sign some papers so they'll let me go. And then he got arrested again. He didn't know what for. And then came the 3rd time. He was a passenger in a vehicle. He was offered a ride home from somebody who was lived in the same neighborhood he did. He got in, they pulled over, the people went in the store, cops came by. Next thing you know, he's being arrested for something found under the driver's seat. And, but the cops said they smelt marijuana, so, they got him on. They made no arrest for marijuana. And the people that actually were driving the car, they didn't arrest them. They couldn't find them. The car wasn't towed. They didn't bother to find out who the owner was, etc., etc. So when he went to court, they said, sign this and you can go. So he tells me, what about a probable cause hearing? And I looked at the public defender. The public defender looked at him and says, the judge ain't going to like that. You should just sign this and go. So I said, so he'll be leaving with a misdemeanor? Oh, no, not really. What's he leaving with? What's that piece? Yes, so it came out it was a felony. He said, yeah, but see, it's not really a serious felony, and you just signed this, and you can go. And I said, don't, kid. I said, because you leave here, they're going to tell you can go, and a month or two down the road, the sheriffs are going to kick in your door and arrest you because, you're a three-time offender, the three strikes law. And then you will get an extended period of time because, you're a habitual criminal. He said, for what? I said, for all those 3 cases that you signed away so you could just walk out of there. You walked out of there so far with felonies both times. Am I correct, public defender? Well, I haven't checked her. No, she knows. And this 3rd felony, that's going to make you, a habitual offender, 3 strikes law. They're not going to use it right now. And he just kept looking. Isn't that true? And she got mad, and she went and told the judge. They gave him a probable cause hearing, put him at the end of the docket, so he was the last one in the day. And the judge was pissed because I was sitting in the courtroom, the only person in the audience sitting and I sat in front because I couldn't hear what was going on, and the judge yelled at me simply because I was advising this kid of his constitutional rights, which he was being denied. They were refusing to live up to their constitutional duties, and the state's attorney sat back and laughed. And the judge says, well, I know where this is going. This is going to trial at 26 in California, which it did because the judge didn't give a crap about no probable cause. So it went to trial, and they spent almost a year trying to convince him that the judge is really pissed that he's not accepting the plea deal, and they wanted to throw more charges at him when the public defender mentioned that. I said, oh, seriously? Like, I didn't expect you to violate the double jeopardy clause. 3rd part or double jeopardy clause clearly states you cannot try or convict somebody multiple times for the same crime, and you're threatening that? So they didn't charge him with multiple crimes, and I couldn't my body gave out. I couldn't drive I couldn't walk. The cops helped me back to my car, thank God, when I left the court. That was the last time I appeared. I didn't see or hear the kid for some time, and when I did see him, he told me they threw the case out. I think they eventually gave him a motion to quash. It was basically no probable cause. They threw the case out. And that saved him for going to jail on the 3 strikes law. And I keep trying to explain to him that he could file a case with the DOJ on a conspiracy against rights under the color of law. And I says every person, in that case, the judge, the state's attorney, and the public defender will be charged with deprivation of rights, and because nobody abided by or enforced the rules and the codes, which are the duties of all lawyers and judges in every court of law. And considering the fact that that's misconduct, and reporting misconduct is mandatory, nobody reported misconduct. They were legally obligated to report each other as well as themselves, because reporting misconduct is not limited. It doesn't say you have to report anybody except for yourself. It says reporting misconduct is mandatory. Any lawyer or judge having knowledge of any lawyer or judge violating the rules or the codes is legally obligated to report that. And it doesn't say unless it's your friend or yourself or your sister. But see, nobody abides by the rules or the codes. Nobody reports this misconduct. So it's easy to prove, a conspiracy against rights under the color of law using the rules and the codes, because nobody abides by that. If you read this in its entirety, it tells you, how a prosecutor, if they know, it says down here, what a prosecutor knows of new and credible material evidence creating a reasonable likelihood a convicted defendant did not commit an offense of which the defendant was convicted, prosecutor shall properly disclose that evidence or appropriate to the court of authority, and if the conviction was obtained in the prosecutor's jurisdiction, properly disclose that evidence to the defendant unless the court authorizes delay, and undertake further reasonable investigation and make reasonable efforts An investigation determined whether the defendant was convicted of the offense the defendant did not commit when the prosecutor knows of clear and convincing evidence establishing the defendant in the prosecutor's jurisdiction was convicted of offense the defendant did not commit. The prosecutor shall seek remedy to that conviction. Okay, prosecutor's judgment in good faith. The evidence does not rise to standards stated in paragraph through subsequently determined to have been erroneous does not constitute a violation of this rule. But it's rare that they use that. You can prove anything that they... I proved it numerous times. But considering the fact this was before social media and all this stuff that's going on now and everybody that's helping each other out and making each other aware, that's what I'm trying to do, divulge, the lawyer, your lawyers, every judge's legal responsibilities to your court of law, not just to you personally, but to the public in general. Okay, it's a we the people thing. Okay, so and I used this before, and this wasn't in the 79 one, but it says it's from the Supreme Court. Let's see, the state's attorney's official capacity is representative of all people, including the defendant. It is as much his duty to safeguard the constitutional right of the defendant as those of any other citizen. In 1935, the United States Supreme Court described the duty of a federal prosecutor as following passage. The United States attorney is a representative not of an ordinary party or controversy, but a sovereign whose obligations to govern impartially is compelling it is obligation to govern all, with whose interest therefore a criminal prosecution is not to shall win the case, but the justice shall be done. As such, he is particularly a very definite sense the servant of the law. That goes for all lawyers. They're all servants of the law. Same thing with judges. They're servants of the law. As he is such particular, very definite as a servant of the law, a twofold aim which that guilt shall not escape and innocent not suffer. He may prosecute with earnestness, vigor indeed, he should do so, but while he may strike hard blows, he is not at liberty to strike foul ones. People, if you don't know this, you should know now, and then you'll realize the foul blows that are always coming. They're hitting you with turduckens. And I don't like turduckens. That's as foul as you can get. So, people, there's just so much you need to know. But that's what the public defender was complaining about, trial court publicity, and what does Rule 3.8 add to it? Okay, so they're violating the trial court publicity. They're violating special responsibilities of the prosecutor. It's totally ridiculous. Nobody gives a crap about the law. People, that's why I keep saying, when you go to court, take the code of judicial conduct, because the judge won't give a crap about that. So you're going to have to go over the code of judicial conduct with the judge in court, and then go over the rules. So that way everybody plays by the book. Okay? You won't always win, but you won't always be the loser. Okay? And at least that way the truth will come out. You'll be able to get disclosure, discovery. That's I forgot what through expediting litigation. You'll find that in expediting litigation. It's up here. Partiality and decorum toward the tribunal, which that doesn't happen. Fairness to the opposing party and counsel. Their argument was in court with me. They gave discovery to my counsel, and I made it clear. It says fairness to the opposing party, which is me, and counsel. Who does it speak of first? Who comes first? Who does it go through first? I'll hold you to the letter of law that in every court of law, and your own lawyer will hold back evidence and make excuses why he didn't get it and bring it up with the judge. It's called candor towards the tribunal, okay? So there's a lot of things you're going to want to discuss in a court of law. A lawyer shall not knowingly make false statements of fact, law, in a tribunal. I mean, is that so hard to understand? Expediting litigation. A lawyer shall make reasonable effort to expedite litigation consistent with the interests of the client. Well, you really got to be, it takes a whole lot of stupid not to do that. But they'll put a whole lot of stupid in what they do if you don't bring this up. Okay, meritorious claims and contentions. Lawyers shall not bring or defend a proceeding or assert controversy an issue therein unless there is a basis in law fact for doing so that is not frivolous. Okay? So that's what I'm fighting in eviction court. Frivolous litigation, which includes a good faith argument for an extension. And they have no good faith argument. They just don't want to make all the mandatory repairs. The landlord, and I got him on video saying, you think you need special attention because you're handicapped. No, I've got letters from all the other landlords. And never once did I ever ask for special treatment. Okay, serving as a third party neutral. So that's where they want me in that early resolution program to talk to lawyers who will try to talk me into doing what the opposing party wants me to do, because that's what the judge wants me to do. I'm wasting a whole lot of the court's time here. Anyway, this is eviction court. This is what you're here for, you fucking morons. Duties to a prospective client. So when you're looking for a lawyer, you should read that. Okay, you should read all of this when you're looking for a lawyer. When you're talking to a lawyer. You know, when safekeeping property, clients with a diminished capacity. And you could use that for yourself because you don't know anything I'm talking about, okay? So, when a client's capacity to make adequately consider decisions in connection with representation is diminished, whether because of minority, mental impairments, or some other reason, the lawyer shall, as far as reasonably possible, maintain a normal client relationship with the client. Okay, so just consider yourself a client with diminished capacity, okay? So you can use that against them because you don't know jack when it comes to the law. And they'll tell you ignorance of the law is not a valid defense. And you could use that against them because you're ignorant of this law because didn't none of them tell you, you know, and you heard it from on the internet from some old guy. So you decided to look it up and discovered you are a client with a diminished capacity and all this stuff is happening and should be happening. Duties of former clients. Fees. I mean, seriously. They're not doing this and they're charging you for not doing this. Did anybody communicate that to you? Anybody communicate any of this to you? A lawyer shall promptly inform the client of any decision or circumstances in respect of which the client's informed consent. Inform yourself about informed consent. I did a video on that. I typed it in, inform yourself about informed consent, and then it turns out somebody else was explaining it, and these were lawyers, so I strongly suggest you listen to them about informing yourself about informed consent. And this would include that because it would fall in lines with discovery. Okay, that's called disclosure. Look up disclosure law. So this would be a lack of disclosure. Disclosure is mandatory in every court of law, folks, okay? So communication, remember, who's communicating this to you outside of me? Diligence. I told you, they don't do this. A lawyer shall act with reasonable diligence and promptness in representing a client. Why do they do that? You know why they don't? Billable items. Always creating billable items. Would that be competent? Is that competent? A lawyer shall provide competent representation to a client. Competent representation requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. You know, you can read it all in the comment section there. But seriously, is that competent? Is not doing any of this competent? You should read the preamble of the scope, because nobody's doing none of that there. Okay? Nobody. This is a whole lot of not getting done. Okay, so I keep telling you, people, you know, if you want to prove ineffective assistance of counsel, all you need are the rules. Always start with the rules first. Okay, screw what happened in court, because that you'll, after you tell your tale by what didn't happen in here, okay? So this is where deprivation of rights starts, and you know that's federal law, violating federal law. Look it up, deprivation of rights, okay? And you have meritorious claims and contentions. Nobody expedited litigation. You're just expressing candor towards the tribunal. You know, there was a lack of fairness to the opposing party. You're just you're just looking for impartiality and decorum in the trial, in the tribunal, in the court. You want to call all these lawyers at witnesses, and they're going to suck at it, and then they're going to need lawyers because, you know, in the legal business, they say only a fool represents himself. So, I mean, they were foolish enough to represent you without representing you. And now you know. They're not doing a lot of stuff they're supposed to be doing. I hope you're listening. Truthfulness in statements to others. I got. And of course, they're representing a client. A lawyer shall not knowingly make a false statement or material fact of law to a third person, or fail to disclose material fact when disclosure is necessary, avoiding assisting a criminal or fraudulent act by a client. And that's what they're doing in my eviction case. They're not doing that, and they're not going to do it in court. And I'm going to make that relevant in court. I actually got sent a letter from a lawyer saying they'll represent me for so much money. They're not going to do any of this. Even people acting in the lawyer's behalf, you know, working for a lawyer, can be held responsible. And they can also be included in that conspiracy against rights under the color of law. Because if your lawyer's doing this, remember, it's the opposing party and the judge's legal obligations to make sure your lawyer's doing all this. They're supposed to be watching each other, making sure everybody abides by the rules and codes. If not, they got to report them. Call misconduct. Accepting appointments. Law reform activities affecting a client. You're going to want to read that. Communications concerning a lawyer's service. You're going to want to read that. Solicitation of clients. I said I got a letter from somebody saying, how the hell did they even know? Court. But I got those before. Bar admission and disciplinary matters, you're going to want to look that up. Disciplinary matters. Reporting professional misconduct. See, it used to say reporting professional misconduct is mandatory. It still says it when you open it, but the title clearly said. A lawyer who who knows of another lawyer has committed a violation of the rules shall inform the appropriate professional authority. A lawyer who knows a judge has committed violation of rules of judicial conduct that raises a substantial question to the judge's fitness shall inform the appropriate authority. They don't do that, so you got to do that. When you do it, just look up rules of professional conduct complaint form with the Code of Judicial Conduct complaint form, okay? Misconduct, see, so it says reporting misconduct. Look at misconduct, it says right here. If a lawyer, it is professional misconduct for a lawyer to violate or attempt to violate the rules of professional conduct. Knowingly assist or induce another to do so. See, so they are conspiring. It's a conspiracy to deprive you of your constitutional rights. No matter what courtroom you go into, this isn't happening. So no matter what courtroom you go into, there's always a conspiracy against rights under the color of law. They took your kids, they took your house, they took your grandpa, hid him away somewhere, and emptying his life assets, taking his, conservatorship, guardianship. You can stop that yourself using the law. The rules of professional conduct, what everybody's supposed to be doing and nobody is. So people, quit saying it's complicated. It's not that complicated. If you look up the rules of professional conduct, you're going to say, hey, they didn't do this. That's deprivation of rights. And you just go through everything they didn't do. In every court, there's different rules that will apply. But in every court, the rules apply. So you won't use all the rules in every court, but you'll always use the rules in every court. Same thing with the Code of Judicial Conduct. You can't violate one, I just showed you, violating rules of professional conduct, it's difficult just to violate one rule. When you violate one rule, you violate multiple rules. And when you violate the rules, you not only violate the rules, but anything said in the preamble or mentioned in the scope. So that makes basically anything and everything in there, and their legal mandates, their legal obligations, their constitutional duties to you, the general public, as well, has been null and void, which is highly illegal. Okay, so remember I said, see, conspiracy against rights under the color law refers to the federal crime of two or more people agreed to injure or threaten to intimidate anyone to free exercise their constitutional rights while using government authority to do so. It is aggressively prosecuted by federal authorities under USC 241. Okay. So hit them all up. Hit them all up. There's a lot of civil rights, a lot of government agencies with civil rights divisions. Look everywhere. People say, oh, which one should I file with? File with everybody, okay? If you file with everybody, they're going to have to cannibalize each other. Okay, right here. See? Pretty simple question. When judges and lawyers conspire to violate ethical codes, the rules of professional conduct, and the Code of Judicial Conduct, okay, those are ethical codes, and you can also file for ethics violations, okay? So when you file for violations of the rules and the codes, you're going to also want to file for ethics violations as well as with the DOJ and all those other departments. But when a lawyer and judge conspires to violate ethical codes, they breach their oaths and undermine the integrity of the justice system. Both professions are governed by strict independent ethical frameworks that specifically prohibit colluding to bypass legal procedures or professional standards. That's violating the oath as well. Okay? So look. Lawyer is governed by the rules of professional conduct. It always mentions the ABA. Okay, because that's where it starts. That's the foundation of the rules of professional conduct in every state. The rules strictly prohibit any attorney from knowingly assist a judge in violating the Code of Judicial Conduct. Judges governed by the Code of Judicial Conduct. Judges are not allowed external influence to dictate their ruling and are required to act impartially. The mandatory duty to report. Okay, I told you. Both lawyers and judges are bound by mandatory reporting rules. If an attorney discovers a judge or another lawyer is engaging in serious misconduct, they are ethically required to report to the appropriate disciplinary authority. Failure to do so is an ethical violation in itself. Sounds like I wrote that. Judges also have a mandatory duty to report attorneys who engage in dishonest and fraudulent behavior. So I'm going to demand that when I go to eviction court. Okay. How are such violations addressed? Because the user is located in Hickory Hills, Illinois, misconduct is handled by specific state agencies. For attorney, misconduct is investigated and prosecuted by the Attorney Registration and Disciplinary Commission of the Illinois Supreme Court. I keep telling people, when you file these complaints, that's where it goes to, the Supreme Court. I know that because I found that out in the 80s. For judges' misconduct investigated by a Judicial Inquiry Board, JBI. If formal charges are filed, they are heard by the Illinois Courts Commission. People, you can seriously get any judge, any lawyer for misconduct if you just read the rules and the codes. You know, it's harder to get you to read the rules and the codes than it is to get the judges and the lawyers to abide by them. They're breaking the law by your ignorance of the law, and they're going to use your ignorance of the law against you. They're going to tell you that's not a valid excuse. And if you look it up, ignorance of the law is not a valid, it's not a valid excuse for you. You can't, if there's some things you could use it on, like this, you didn't know, you are just acquiring the divulgence of what has not been told you before. This is just a massive divulgence of what should be happening that isn't. Divulge means I'm just informing you in a legal context. I'm just informing you of what you didn't know, but you should know. Okay. Okay, so to understand the statute of limitations for filing a grievance. The Judicial Inquiry Board and the Attorney Registration Disciplinary Commission, they do very little, if nothing at all. Okay, but once you mention deprivation of rights, violating federal law, and how they work together, which created a conspiracy against rights under the color of law, and for them to fail to cite these lawyers and judges for violating the rules and the codes and conspiring together to deprive you of your constitutional rights in a court of law, they would be adding to this conspiracy against rights under the color of law. And they will add to it. But not if you bring up a lot of the stuff I mention in my videos. These are the ones I use directly on my computer. My history, I keep deleting the history because I like to go through things I haven't read, other states, check the variances, the deliberate deletion, omitting, redacted parts that were there that are gone and are back again. But that's because, I've been helping people. And thank God I learned how to use the internet. When I went to school, we didn't have computers. Didn't have calculators. Closest I had to any of that was an abacus. I asked people if they could help me learn. Nobody would teach me. So I bought a computer, put it together, and figured out how to program it and find my way. If my old ass can do it, so can you. But I'm giving you a head start. What I had to go through, the books, you won't have to go through. Just go through my videos and pick and choose. Remember, misconduct. Mandatory to report misconduct. Everybody's misconducting. I'm telling you, it's an epidemic. It's worse than the Black Plague. I'm not talking about this pandemic that only killed millions of people. I'm talking about the Black Plague in history. It killed millions and millions of people. So many of you lost so much because of all this misconduct. And it always happened and keep happening until you start opening your mouth. I can't be there for you, but I can help you be there for yourself like I was for me. Have your back like I had mine. Teach you what I taught myself. If I can do it, you can do it. I'm not the smartest person in the world. Never considered myself a genius, yet alone a stable genius. I just read a lot. If you want to call that smart, well, what if you read the same thing? What if you read the same things I did? You have that opportunity. You have that opportunity. It's your choice. It's for free. I'm giving you what I spent years putting together and had to find ways to get this information to you. I used to go to the courts with copies of the rules and the codes and complaint forms, etc., teaching people. I got chased out of courts. I got threatened by lawyers, left for dead because of a judge. And I'm still not stopping. And I'm going to get back into it with them again. I'm going to start filing again, repeatedly like I did in the past. I was warned if I didn't stop, things would happen. But I stopped doing what I was doing for me, and I started doing it for we the people. And that's not actually where I started. I started helping people before I was having problems. But I knew what was coming. I was prepared. And I want you to be prepared. This is a war, people. This is a war on your constitutional rights, the Bill of Rights, your civil rights, as a United States citizen, your birthrights. I can't do this alone. You need to read to succeed. I want you to succeed. I've helped many people, not many as I desired, and I've always felt a tremendous guilt because of these deprivation of rights. And why should I feel guilty? I'm not doing it. I'm trying to stop it. And I need your help. I need you to open your eyes. Do a little reading and open your mind. And it'll affect you like it affected me. It won't only be in your head, it'll be in your heart. And live up to the Pledge of Allegiance. It wasn't just to the flag, it was to what the flag represented, the common denominator in both the Declaration of Independence and the United States Constitution. 3 simple words: we the people. That's who I pledge my allegiance to. Where is yours? Where are your loyalties? I took a pledge of allegiance. They took the oath. I lived up to the pledge. They have yet lived up to the oath. Here we are, nearing 250 years celebrating the Declaration of Independence and the Constitution. And yet and to this day, it has yet to be fulfilled. All I've seen, not just for me, but for we the people, are shattered dreams because of so many broken promises. And that's what I'm offering you. No more shattered dreams, no more broken promises, but you need to stand up for yourself. They'll tell you ignorance of the law is not a valid defense. And I'm telling you the same. They're telling you you can't possibly learn what I learned. I think not. I know you can learn anything I did. Anything and everything. A protege thought I was smart till he read what I read, and he's finally realizing his potential. He's finally realizing that he has yet to begun to fulfill his mind. That's what I want you to do. Realize your potential. Realize who you are. Remember, anytime, every time anybody asks you, who the hell do you think you are? Reply as I would, we the people. That SOB, you took an oath to serve and protect. Not just me, one of many. When it comes to we the people, I am many, and from this day forward, we are one. We are all craving the same thing, the rule of law. Where it's said that we are endowed by our Creator with certain inalienable rights. Amongst these are life, liberty, and the pursuit of happiness. And the forefathers even wrote those that would usurp those rights. Those despots are duly right to be removed and replaced. So let's finish what they started. Come this year, when people celebrate the 4th of July, maybe they'll all stand up together and pledge of allegiance in recognition of who they pledge allegiance to, we the people, each other. I wanted to do this Memorial Day to honor those that served, past, present, and and our future, but mostly to those, the encampment at Gettysburg, not Gettysburg, Valley Forge, the encampment of Valley Forge. Everybody there, everybody that served there. What they were promised was never fulfilled, and we are suffering that to this day now. Deprivation of rights under the color of law. It needs to stop, and I need your help. All right, thank you. Good night. May your Creator always be with you and rain many blessings. May you have a long life and good health. May peace always be with you. Love and happiness, y'all. Nothing but love and happiness.